Good afternoon, ladies and gentlemen. Welcome to the 7 Deadly Clauses, a webinar brought to you by AIA Contract Documents. Before we get started, there will be a few administrative items. Please note that this webinar is being recorded and you will be emailed the webinar along with the PowerPoint slides by tomorrow close of business. We'll also be uploading this webinar on demand to our Learn page on aiacontracts.org. This presentation is protected by U.S. and international copyright laws. Reproduction, distribution, display, and use of the presentation without written permission of the speaker is prohibited. This course is also registered with the AIA for one learning unit. When you registered to attend this webinar, you entered your AIA member number if applicable. We'll use that information to report your credit directly to the AIA within 2 business weeks of today's webinar date. Here's a disclaimer that this webinar and all AIA contract documents education is not provided as legal advice. It's for informational purposes only. Always best to seek appropriate legal counsel on particular facts and circumstances at issue. And with that, I'm going to turn it over to one of our presenters to introduce themselves and begin the webinar. Peter Noon.
Thanks, Hasti. Hello, everyone, and thanks for joining us. I'm Pete Noon with the firm Solomon Cordwell Benz. We're an architectural and interior design and planning firm with 3 offices located in Chicago, San Francisco, and in Seattle. We focus primarily on large commercial projects, including multifamily residential, corporate office, hospitality, and retail. We also do laboratories and quite a bit of academic and institutional work, as well as aviation and transportation. I'm the managing director of the San Francisco office, and in that capacity spend a lot of time negotiating contracts, among other things, and I'm a member of the AIA Documents Committee, as well as a director at large for the San Francisco AIA.
And hi, everybody. My name's Pete Longley. I'm the Chief Operations Officer for CBT Architects. We're a Boston firm. We have a staff of about 190 architects and interior designers. We also do large commercial projects, much of it multifamily residential. And I had the pleasure working with Peter on the AIA Documents Committee. We were both part of the group that issued the 2017 versions of the A201 family documents, which all of you have been using now for 3 years. So, without further ado, here's our learning objectives. So, we hope to learn how to establish an effective process for conducting a review of contracts. We're certainly going to spend a fair amount of time talking about how to negotiate them. We're going to go through a list of problematic clauses that are those which are often overlooked. We hope to gain some tools and strategies for how to effectively negotiate. And we're going to learn where to access reliable resources and contacts. And Pete, I'm very curious, so you negotiate a lot of contracts. What are some of the resources that you use?
Well, we're fortunate we have inside counsel, but in my previous life working at smaller firms, we always asked and reviewed contracts with our outside counsel. Our insurance carrier provides great service as far as reviewing contracts for insurability and pointing out troublesome clauses like we'll talk about today. And, you know, I talk about, as you do, Peter, at the AIA Documents Committee, I reach out to colleagues and we talk about, you know, war stories all the time. So I'm mining my resources with my other contacts doing similar kinds of work.
Yeah, and I have to add that neither one of us are attorneys, although I have to tell you, more than once or twice I've been accused of being one.
Yeah, same here.
Here we are. The AIA Documents Committee is a wonderful organization. The first contract that they issued was in 1888. It was a construction contract. The AIA documents are really the industry standard. Our committee and the AIA are very proud of the iterative drafting process that we go through, the market research that we do, the industry stakeholders that we involve. We work with AIA member resources, including the attorneys that are on staff for the AIA. We work with outside liaisons. We want to get the input of owners and contractors, not just the ears of architects, because it's very important that our documents come across as being fair and balanced. And that is really entirely what it is that we're looking for. And then, of course, we have 30 some odd volunteers that are part of the AIA's Contract Documents Committee, and we help to pull together the documents that we have. So, as for our presentation, we'll start by asking, what are the 7 deadly clauses? Pete, you were going to say something.
Yeah, I mean, I'm sure that was a question on a lot of people's minds, like, hey, this sounds really serious. Well, you know, Peter and I have been thinking about this for a while. This is a result of a lot of over lunch and over breakfast discussions at documents committee meetings with a number of our colleagues. These are clauses that aren't typically covered in your loss prevention seminars given by most insurance carriers and a lot of the attorneys out there. They're a little more out of the ordinary, things that we've been running across in manuscript agreements. And these are things that, you know, can be quite troublesome and, in fact, are proving troublesome on a number of projects. And the thing that I seem to always get when we're trying to negotiate these things is a comment from the owner that, well, every other architect agrees to this. Why won't you? What's special? So the hope here is that we're educating our colleagues and to be able to successfully negotiate and not allow the negotiating ploy of saying, well, everybody agrees to it, why not you?
Yeah, we're hoping to kick the legs out of that argument by having more people agree to it. You know, by having more people agree to our perspective on why these clauses are such problems. You know, the other thing that I wanted to mention was there's a great book, and those of you who haven't read it should get out and get a copy of Getting to Yes. It's written by Roger Fisher and William Ury. It's a very helpful book that helps you to understand, to try to get into the head of the other party so that you can see what it is that they're interested in accomplishing in the course of a contract negotiation. Because oftentimes somebody will come up with an idea and they think they have a solution for how they want to accomplish it, but that's not really what it is that they're trying to accomplish. So if the negotiators can understand what the other party really wants, then they might be able to respond in the negotiation process to come up with language that both parties can find to be acceptable. So as we go through these 7 clauses, you're going to see that there's a pattern. We identify the clause. We identify what the owner's interests are in proposing that clause. We talk about what us as an architect, what our concerns ought to be with what the owner proposes. We'll look at some negotiation strategies for how to work your way through these, and then lastly we'll see some AIA language on the clause and how to disarm the clause. So we have our first deadly clause. Pete.
Yeah, this is one that's coming up more and more in some of our agreements, especially if we're working with some of the tech companies, certainly with institutions of any sort, especially higher learning, cities and so forth, and it's the ownership and use of the instruments of service. So we'll see a clause often that looks a lot like this, and I'm not going to read through the whole thing, but there are some words in here that are quite problematic. So the first would be that we're warranting that all designs, drawings, and every other document of every other kind whatsoever is the property of the owner, and that they will become the sole and remain the sole property of the owner whether or not this agreement continues or is terminated, and that can be quite problematic. Then there's the use of the instruments of service. So these things go hand in hand. So the owner would be granted a perpetual, unconditional, irrevocable, worldwide, and assignable license to use and make derivative works, and that's important, derivative works, from the instruments of service. So these things, it allows the owner to make repairs, additions, renovations, which is all fine, but make other derivative works from the instruments of service. These things can be quite deadly.
So what does the owner really want here? I mean, obviously he's looking for flexibility. He'd like to be able to terminate the architect without having to start over. He wants to be able to take all that has been designed and give it to replacement. So he wants the ownership of the instruments of service, the IOS, for future use without any restrictions or obligations of the architect. He wants to control the intellectual property and be able to manage it. So what are our concerns, Pete?
Well, first there's a very concerning one, which is the loss of the intellectual property rights for our standard details and material applications. Again, if you go back to the language, we're returning over everything to them, and it becomes their property, including our standard details. And without those, most of us can't do business. We're also concerned about misuse of the instruments of service, which could put the health and safety and welfare of the public at risk. Obviously, that's a bad thing. And then really there's the unintended expansion of our liability. So we would be liable potentially for incomplete work that we're not allowed to finish if they take our instruments of service and use them for another purpose without our involvement. We could be liable for the completion of unfinished work by a third party. Say they give our instruments of service to another architect to finish. They don't have a lot of incentive, perhaps, to fully coordinate that which we've already done, and there could be problems there. And then there's just functionality and safety concerns when they a third party makes changes. For instance, there may be some specific fire or life safety issues that they would unwittingly change by making changes to the additional service or the instruments of service.
They could actually create an issue that is now no longer code compliant.
Right.
So if we begin to think about how we negotiate this with the owner, clearly our intent is we're doing these services so that the owner can have the documents to be able to use them for the intended purpose. That's the whole purpose of this owner-contractor agreement, to create that for him. So, and we'd like to be able to correct any alleged deficiencies before they lead to a claim, before they usually become a change order and that leads to a claim. And the owner certainly would have the right to use these things for ongoing maintenance. We don't have any problem with that. But we'd like to say that the license for the owner to use these documents is predicated upon paying for the service. So really, there's two provisions here. We'll transfer ownership of the unique design aspects of the project, provided you pay for the service, but we'll retain ownership of our standard details, and without which, if we give them to you, we're going to be going out of business. So we need to bifurcate this discussion. into things that we have to continue to own and things that we're willing to allow the owner to own.
Right, and then,
yeah,
then when we talk about changes made to our instruments of service, we would want to negotiate some release from claims if we're not involved in any changes to those documents, and we want to be indemnified for those claims.
Right, because you're talking about shifting the responsibility onto the replacement person who made it non-compliant, right?
Right.
So why should we be responsible for what somebody else caused after it was out of our hands? So there's some great AIA language. You can go. We're going to skip through this just to move things along. You'll get a copy of this slide. You'll be able to look at this language. It's from Article 7 of the AIA B101. There's also some use text that you'll find in the same document. And then lastly, we get to the clause that came to us, this manuscript thing, and we want to be able to figure out how we're going to disarm this thing.
Right. So the first thing that we want to do is take out the word warrant. That has a lot more meaning than we would want to have. We just want to agree that upon payment of all undisputed sums, in other words, we get paid, then we'll give the final plans and drawings, specifications, and so forth, reports to the owner as their property. We also want to make sure that it's not everything. You can imagine.
Yeah, they only care about the final design. They don't care about the schematic design documents, really.
Right, or all the little sketches and notes and things that would be implied by the language of the agreement. We want to strike out things such as whether or not the agreement continues or is terminated. If the agreement is terminated and we're not paid, then it would be important to make sure that we're retaining the rights to the instruments of service. But we would add that the owner acknowledges that the work product as defined in this section excludes the standard details of the architect and his consultants. That's important.
Right. Again. We're going to keep owning those.
Yeah. And then we put in something about upon payment of all undisputed sums. That's important. We want to be paid. And then we would give the license to use solely and exclusively for purposes of completing the project and making later repairs and renovations and so forth.
Right. This is about using the standard details.
Right. And then we give them the
license. They already
license.
own the unique stuff.
Right. And then we give them the license to use those standard details with any successor owner. And then we would want to have a release and indemnity for any changes that are made.
Okay. The second deadly clause, the right to withhold or offset fees.
Yeah, this one's my personal favorite. It seems to be on just about every manuscript agreement that we see. So the owners want to retain the right to withhold any payment from the architect in order to defend a claim that we're not making payments to our consultants or other vendors. They want to be reimbursed for any back charges or claims that come from the contractor during construction that may have been the result of an error or an omission. And they want to protect the owner from any breach by the architect.
Any breach.
Any
right?
breach, yeah, right, exactly. Right. So these things are all quite problematic because usually there's a clause that also says we have to keep working, we can't stop work, and we don't have the right to terminate for anything other than cause. But if they're not paying us, that's no longer a
right.
cause that allows us to terminate.
And you can't even collect interest on the unpaid bills.
Right.
So really, what does the owner want here?
Well, I think it's fair that they want to not have to pay for incomplete or unsatisfactory services. That makes a lot of sense. They also, I think, and quite fairly want to be protected if we're not paying vendors or consultants. They don't want a lien slapped on their property. But in some ways, they're looking to gain some leverage, too. They want to compel us to complete services, so there's always a club they can hold over our heads. And in the end, there's often times where there might be gray areas where there's a disputed additional service, and they can use withholding of payment as an additional incentive, if you will, to provide free services. Yeah. And then they want to resolve negligence dispute without ever having to litigate it. They just want to.
Yeah, that's really the bomb here in this whole mess.
Right.
So, what are our concerns? Well, certainly we like to get paid.
That's important.
To provide services, but we need money for that, so we'd like to get paid. We're concerned about establishing a contractual liability, which we'll actually talk about a little bit more. Doing so would jeopardize insurance coverage for errors and omissions. And the owner may use the right to withhold our fees to compel us to do free services or to wring other concessions from us, really for the whole rest of the contract, from the moment the first withholding begins.
And as I mentioned, you could be compelled to continue working on the project indefinitely without being paid. That's quite a frustrating position to be in. And the last thing, read your insurance policy. The legal fees that you may have to expend to recover fees arising from some contractual liability. In other words, you haven't been paid, you have to hire a lawyer to collect your fees, or there's a claim and you might be hiring two lawyers because the lawyer to represent you for the claim would not be the same lawyer that is representing you for the contractual liability of the recovery of the fees, because recovery of fees is not generally covered by your insurance.
It's not negligence, so it's not covered by E&O insurance. So yeah, you're looking to hire two attorneys, one by the insurance company and one out of your bank account.
Right.
So how do we negotiate this? Well, we say the owner really already has by law the right to withhold payment for incomplete and unsatisfactory services. If I send a bill that says I'm 50% done with design development, and the owner says, no, you're only 25%, there's no reason why he has to pay any more than 25%. So that's not really the issue here. The real issue, the real concern with the withholding is that our insurance might not cover. So what I always tell our clients and our clients' attorneys when we negotiate this issue is we buy insurance for your benefit as required by this contract, and that is where your best recourse lies in the event that you're harmed by any error or omission on our part or on my part. And the last thing you want to do is jeopardize that benefit.
And quite often that doesn't work, and the owner is going to insist on some amount of withholding or ability to withhold your fee. So what do you do then? Well, we have been pretty successful in setting a maximum amount of fee that can be withheld before we're allowed to stop services. Certainly we want to require notice of intent. In other words, the owner can't just not pay a bill because he's not happy. He has to let you know, and there's notice requirements in the agreement. We want notice of that intent to withhold. And then ultimately you want to have a dispute resolution process that is fair and equitable, that would allow both parties to resolve disagreements about any withheld fees.
There's great language in the AIA B101 in Article 11, and that's the compensation article. I encourage you to take a look at that language. It's actually very fair to both parties. And lastly, there's some great language that would give you the right, as the architect, if you're not being paid, to suspend services until you are paid. Often I've seen this language modified for having to do with amounts that are in dispute, not counting here, but that's the language. And so you can see that bit of clause being added down at the bottom here, where according to Pete's suggestion, we might establish a dollar amount that we holding our noses would allow to be withheld a maximum amount, and they can only withhold it if there's a good faith dispute.
Right, and then of course you want to make sure that you put in some requirement for the owner to provide notice. Here it says within 10 days of receipt of our invoice that they're somehow disputing, and they have to provide us with a written notice and explanation. Again, we put in withholding the amount in excess of the amount that we've agreed to. That would then be considered a material breach by the owner and allow us to suspend and terminate the agreement based on some other provision that would be in the agreement. And that any claims for breach of the agreement or other alleged claims should follow a specific dispute resolution process, whether that's mediation, to arbitration, or litigation. You want to make sure that that's spelled out in your agreement.
The third deadly clause, reliance on services and information that's furnished by the owner. So here we have a sample clause that the architect's basic services shall include all architectural engineering and consulting services required for the complete and fully coordinated design of the project. The architect shall be responsible for the performance of all the services for the project, whether performed by the architect's consultants, or the owner's consultants. The architect acknowledges that the owner is not a design professional and is entitled to rely solely on the expertise of the architect. Wow. So
yeah,
really,
so, yeah,
what does
yeah,
the owner want here?
Yeah, exactly. Well, for one thing, the owner wants to take away his risk and place it on the architect. So if he hires other consultants, he wants to put the risk or shed risk onto you, and he wants to have a place really with one-stop shopping, one person to manage, one bill to pay, and one firm to sue if something goes wrong.
So
Peter,
we're obviously concerned.
Yeah.
We're obviously concerned with information and services that the owner's providing that are beyond our expertise. You know, I might be faced with a position of needing to hire you know, a second mechanical engineer aside from the one that works from the owner to check and see whether there's enough you know, air conditioning being provided for the project. So that's a big concern. And then of course we always have the third rail services. Pete and I call them third rail services. They're services that oftentimes don't have very many claims, but when they do, they can be really big and very expensive. And the last one really falls into the category, hazardous materials falls into the category of whether or not you might have any coverage for a claim.
Right. So when we negotiate these things, you know, the first thing, as Peter mentioned, is to say to the owner, look, it's impossible for me to know the accuracy of the services you're providing. I'm going to have to hire, you know, another consultant at your expense to be able to take on that liability, and that's not an expense that you want. These services aren't covered by my insurance either. You know, if you hire a consultant and they make a mistake, you know, you could be requiring us to rely on their services and information, but without any kind of liability to you. But that isn't covered by my insurance, so you're not protected. And the consultants you hire, they should have their own insurance so that you're appropriately covered for their services, not under our insurance.
One of the issues, one of the benefits to the owner hiring somebody direct is that they have something called privity, so that they can sue direct for a number of other legal causes that they can't otherwise. If they're under our wing, the owner would have to sue us to get to our consultant. So we're happy to let these other consultants work directly for the owner. we certainly can agree to coordinate their services, and that's normally what we do, where we integrate their design information into the overall design of the project. We're not declining responsibility for that. All we're saying is that we'll do that, and if we find any errors and omissions in their services, we'll certainly let you know. But we prefer that they be retained directly by you. There's some great AIA language for reliance found in a B101. There's more language is found in a couple of different places, and so these have been highlighted for you. And lastly, we get to disarming this deadly reliance clause. Really what we want to say is we're going to include the architectural engineering consulting services that are indicated in this Article 3. We're going to kind of stop there. We're providing the services that we told you we would be providing, and some of the other services might be provided by somebody else.
So then we get to the fourth deadly clause, which is very related to the third deadly clause, because in some cases the owners are requiring us to coordinate their consultants. So if you get to the deadly clause, some of the things that are concerning here is that we're coordinating their design, and that they're including not only the owner's consultants, but the contractor's consultants to eliminate any and all conflicts and omissions. In other words, we're coordinating all of the design work to make sure there are no errors and omissions, even if we didn't make them. And it's for the entire project, and that can be concerning too, because we may not be the architect for the entire project. So then, what is the owner looking for? They want to hire often their own key consultants with whom they're familiar. They've got an engineer or some other consultant that they've worked with for a long time. They trust them, so they want to hire them, and they want us to make sure that everything is coordinated. That makes a lot of sense. They want us, again, a single source of responsibility for the project, and again, they want to pin risk or shed risk and pin it on the architect.
We certainly have a higher level of liability if we coordinate third-party consultants versus coordinate with third-party consultants. I mean, in most cases, we're not paid to fully manage these other consultants, and they might not actually even be beholden to us because of the way their contracts are structured. So some coordination language can put liability on us for coordinating the work of contractors or subcontractors in the event of delegated design. As we were before with the reliance issue, we're concerned about the third rail services, and we're always concerned about insurability.
Right, so when we negotiate these things, we often say we're hiring consultants for specific services on the project. They're experts in the field, and we have to rely on their expertise, or I'm sorry, you're hiring consultants, and so we have to rely on their expertise. If we're responsible for their conflicts and omissions resulting from their services, we're going to have to hire another expert to advise us on how to mitigate that, and we're going to charge you extra for that service. And these services performed by your consultants aren't covered by insurance. It's similar arguments to the third deadly clause.
The consultants that you hire should have their own insurance so that you're appropriately covered for their services. That's not everything has to pass through my insurance policy. And I can agree to coordinate your consultant services and integrate their design in the overall design, and I will certainly tell you if I find any errors or omissions in their services. Not looking to dodge that level of responsibility. There's some more great sample text in a B101 about coordinating the services of consultants. And lastly, we get to disarming the clause. Pete?
Right. Yeah, so we, talk about coordinating their services, not coordinating their design. So that's an important distinction. And we will coordinate that with your consultants and with our consultants to make sure that the project is coordinated, at least as far as the services go. But they are responsible for their design.
And we're not coordinating the contractor's consultants. That's his
Absolutely.
job.
That's true.
Limiting consultant liability. I've probably written 500 consultant agreements in the last 4 or 5 years, and I always get this sort of a clause attached to a proposal that gets sent to me where it says the consultant's total liability to the client, and in this case, that's me, the architect, arising out of the services of this agreement shall be limited to the greater of the consultant's fee or $50,000. So clearly the people writing these standard terms and conditions for consultants have all been to risk management seminars, and I have to credit them for that. They want to limit their liability. They want to follow the rules of everybody that's giving them great advice. But furthermore, the limitation of liability that I, as the architect, might get under the owner-architect agreement, it may be well beyond their insurance limits. Perhaps I have a $5 million limitation of liability and they have $1 million in insurance. I see that all the time. They are looking for a limitation that's less than whatever I've been able to acquire in my negotiation with the owner in the prime agreement. So,
yeah, so what are your concerns?
We talked earlier about contractual liability. So here, Pete, you can explain what it is.
Okay, well, a contractual liability excluding it's excluded from your professional liability coverage. So if you have a contractual liability to limit a consultant's liability, you're not covered by your insurance necessarily for the amount of the claim that goes beyond your insurance coverage or what's allowed by your insurance policy.
Right. So what do I tell my consultants? I say, well, what you're requesting is not covered by my insurance. Read your own policy, same as mine. It would not be covered for you as well. And I would have to pay claims arising from your negligence out of my bank account. And we're not your financial backers. We do love you, but we don't love you that much. Lastly, I guess the limit that you and I have already been afforded under the prime agreement is really better than nothing. Have you ever worked without any limit? I've used that line a time or two. And lastly, maybe you could work for the owner direct so you can get your own limitation of liability. And as far as a good sample text for limitation of liability in a consultant contract, well, there really isn't any. You should never agree to some sort of a formula. You should let the judge or jury or arbitrator or the finder of fact interpret the prime agreement if there is a limitation of liability there. In finding the fault and the assignment of any limitation of damages to the consultant gets what they get in the way of any limitation decided by the finder of fact. So don't agree to contractual limitation of liability, and see if the owner would be willing in the prime agreement to give a carve-out to the consultant for any claims that arise out of their services. Some owner might be willing to do that, although I'm waiting to see it.
Yeah, introduce me to that owner.
Yeah. So simply put, don't ever sign a consultant proposal and attach it to a contract without redacting their standard terms and conditions. You should likewise also always respond to consultant proposals. Don't just leave them in your email or in your snail mail box. You need to let them know that you don't accept their standard terms. If you fail to do that, you might establish a legal course of conduct which would be your legal assent to their terms under contract law. The sixth deadly clause, compliance with the ADA. So I often see this clause coming in owner, especially in multifamily residential projects. Pete, you probably see it there too.
Oh yeah.
Where the architect, together with the appropriate architect's consultant, shall review all local, state, and federal laws, codes, standards, and permit requirements, including the American with Disabilities Act related to the design of the project, and they create a defined term, the applicable laws, and shall ensure that the design of the project is in full compliance therewith. Frankly, this is a much shortened version over what I usually see. I often see a laundry list of many, many more codes, and plus the kitchen sink that we're agreeing, might be applicable to the project, and we're ensuring that the owner is going to comply.
Right. So what is the owner looking for with this clause?
He wants a project that is perfect, has no problem. I mean, that's totally reasonable. He doesn't want to have any non-compliance with the applicable laws. I can't disagree with him over any of that. He doesn't want any change orders that might arise over needing to fix things after they've been built, and it's usually built in the wrong dimension because accessibility codes are usually about dimensions and clearances. And the last thing he wants is a civil action or class action suit where people come through after the project is complete and file an action against them.
Well, that all makes a lot of sense to me. I like to think we're pretty skilled architects. What are your concerns?
Well, this is the argument I always use. I say, the building codes are enforced by the local building department. There's a person there with whom that I can meet, and I can discuss the code interpretations. I can look across face to face, and if he gives me a list of things of non-compliance, I can revise the plans and I can get the permit. Or if an issue comes up that was not discovered during the permitting process, it comes up during a final walkthrough by the building inspector getting ready to issue a certificate of occupancy, we can make a few adjustments there. We can add an exit sign. So the applicable requirements in this instance are all reasonably knowable. However, the ADA is not reasonably knowable. It's actually enforced by the Department of Justice, and any decisions there may be appealed on up to the U.S. Supreme Court, and where the requirements may not be knowable at all. And lastly, this point is for anybody that works in states that have their own accessibility codes, as they do in Massachusetts. ADA is often in conflict with local accessibility codes, and I'll include FHA in this list also, which would apply to anybody working in large multifamily residential projects. That's also anti-discriminatory legislation. So I'll tell the owner I can understand the requirements of building code, and the permit and the C of O will be proof of compliance. But ADA, I can't know about. I have no idea that I can't ensure a future ruling of the 9 justices of the U.S. Supreme Court. I don't think anybody can do that. So, and furthermore, ADA may conflict with our state's accessibility requirements. Really, ADA belongs in its own category. I'm not denying they'll have nothing to do with it. I'm not saying I'm going to have nothing to do with it, but it's in its own category. The building department doesn't read ADA. They don't enforce it. I can do my best to interpret ADA. I can exercise the standard of care in interpreting it, but it's not going to be a standard of perfection. And really, you can recommend to the owner, it would be best for you to hire an ADA consultant or an FHA consultant for your multifamily res projects to review the design and give you the legal advice that you need to help manage your risks. There's very good language in the AIA B101 doesn't mention AIA. It just simply talks about the projects, the requirements that could be imposed on the design of a project by the authorities having jurisdiction over that project, and the architect needs to find out what those are and incorporate them into the design. So really what you want to do is you want to remove ADA out of the laundry list, put it in its own list, and come up with a clause that says something like this, that we will exercise the standard of care in order to interpret the requirements and that we, in our professional judgment, might determine are applicable to the project. And that's how we would modify this. We would say that we shall contact the government authorities required to approve the CDs and determine the requirements and incorporate and respond to these in the design of the project.
And last we get to the seventh deadly clause, cue the Oregon fanfare, the prevailing party clause, which may be the most insidious one of them all, because it makes a lot of sense. A lot of times an owner will put a clause in that says if either party employs an attorney in connection with claims by one party against the other arising from this agreement, and non-prevailing party shall pay the prevailing party all fees and expenses, including attorney's fees incurred in connection with or arising out of such claims. That's that can be quite problematic.
So what does the owner want here?
Well, of course, they want to make themselves whole. If they have to prosecute a claim against an architect or the design team and they win, they want to be made whole. They don't want to have to pay for their cost to prosecute that claim. What's fair is fair, right? But there's also the hidden leverage here that when they negotiate claims, they can put the fear into the mind of the architect that, hey, you know, if I have to go to court, this is going to go against you and you're going to have to pay for a lot of other costs beyond just this simple little claim. So it could be used as an intimidation tactic to avoid litigation and paying the owner for minor claims. So
once again, we have a contractual liability here, don't we?
Right. So it's, again, if we have a contractual liability, it's most likely excluded from our professional liability insurance coverage. And so you would be paying these costs out of pocket. And, you know, the sort of somewhat sarcastic, but who defines or what defines the prevailing party? If you as the owner sue me for $10 million for some major claim and generally it's debunked and you might get $10,000 in award, well, who prevailed? Was that you or was that us?
So there's really quite a bit of complexity here because, you know, I've seen a reservation of rights letter from our insurance company related to a clause in which we had a prevailing party statement. The matter did settle. It didn't come to fruition. So I asked our underwriter, well, you'll cover third-party indemnities, which includes reimbursement of the owner's legal fees. So why doesn't that work here? And the issue is that the owner has the architect provide professional liability insurance to protect the owner from liability claims against the owner from a third party suffering injury or property damage. So a suit is filed against the owner. It's not the owner's fault. It's my fault. I'm the architect. So my insurance covers the damages to the owner, and it covers their legal fees to make the matter go away. That makes sense. But in the case of the prevailing party clause, that's for direct damages. So when the owner makes, in essence, a claim against your insurance that you have to protect the owner, he's using the insurance policy to the money that's in the insurance policy to encourage him to sue the insurance policy. So he's making a direct claim and getting and having his legal fees paid in the process. So that's why insurance companies exclude it. I hope that makes sense to you guys.
Yeah, it makes sense to me. And ultimately, the AIA documents don't cover prevailing party clauses. So there's no good text to find in the AIA documents. And really, in all seriousness, there's no good prevailing party text. It's all problematic. So the best way to disarm it is to strike it. And if the owner is intractable, consult your insurance company, consult counsel, because this can get you into a world of trouble. So
that's it for our presentation of the 7 clauses. I think Hasi is going to talk about some additional resources that are available to anybody attending here.
Great. Well, thank you to our presenters for a very thoughtful and thorough presentation. There was a tremendous amount of preparation that went into that, so we thank you for your time and effort. As they mentioned, this is the contact and resources page. You will get the recording from today's webinar via email by tomorrow, close of business, but we'll also be uploading it to the aiacontracts.org/learn page. You can also contact us at the information on the slide if you have any questions about content or the online service. We do have time for questions, and there's quite a bit of questions that have come into the chat. So we will go ahead now and start the live Q&A session. First question that came in. When a client proposes a deadly clause, I remind them that I have professional liability insurance. I let them know that my insurance will not be valid if I accept the clause or indemnity. Then I am not the bad guy, and my client and I are able to agree on language that keeps my insurance in place. Your thoughts?
that's great. That's great tactics.
I couldn't have said it any better myself.
Yeah, absolutely. I think that was common to just about every one of our arguments, is that that insurance is there for the owner, and so don't do something that's going to risk your benefit.
Excellent. Doesn't undisputed sums leave a potential big hole?
Well, yes, I think it does. Undisputed sums, though, tends to be the language that you can that we've been able to negotiate with an owner, because they want to guard against unreasonable bills or unreasonable expenses. But it does, I think, leave potential for a big hole.
Yeah, and having to use that language is always a fallback position. You'd rather just simply say there shall be no withholding, period.
Right.
Unless, as it says in the standard AIA text, we've been found to be liable, or we as architects agree, I agree with you, Mr. Owner, go ahead and withhold it. That's the AIA's position. The moment you begin to step into allowing something, you have to come up with some sort of language to control it, to manage it. Ultimately, you're talking about a relationship with your client. You have to manage that relationship as effectively as you can, and you're going to have to find a way to get past these issues and hopefully to continue the relationship and continue the project through to its completion.
Yeah, I would add that, know your client. There are some clients that language is quite, to us, quite acceptable, because we have mutual trust and respect. And new clients or clients that could potentially be problematic, you should have your radar up for language like that, even when you're trying to disarm a deadly clause.
Okay, next Question. We require the owner to hire the engineering consultants directly. Our LI firm requires this. Is this okay?
Absolutely. The only disadvantage that I could see to not having the consultants work for you is that they're not beholden to you. You know, many architects prefer to have consultants they work with regularly, with whom they have relationships. It's always best when problems come up to have somebody that you work in confidence with to help resolve issues, knowing that you know, however this issue is resolved, they want their next meal with you. And that's always a very important factor in terms of you know, managing a relationship and dealing with problems. If you're not prepared to deal with problems, you're probably not prepared to practice. So you've got to find a way to work through those relationships. But yeah, you know, working for clients who want to hire all their own consultants, I think that's great.
Who defines unsatisfactory services?
Well, I would certainly say the first thing to do is go to the contract. What did I do that is not a part of this standard of care or not covered by the standard of care, and what didn't I do that I said I would do and promised that I would do in the agreement? That's the first step.
Yeah, you know, I think you should be able to know when something is unsatisfactory. You know, whenever you're dealing with these issues, you always have to be honest with yourself. And the last thing you want to do is be having an argument with your client when you don't have all the facts and something might be unsatisfactory, and you're absolutely insisting that no, there's nothing wrong with what we did. You know, I worked for years and years. I worked for Bob Hillier, who at one time had the 4th largest architecture firm in the United States. And Bob always said that sometimes when you're working with your client, that you just need to expose the jugular. He says, and he tilts his head back and shows his neck, and you know, it's like offering the shark a chance to take a bite. And most times they won't. You just have to learn how to be honest about yourself and honest in your relationship with your client.
Yeah, and I would also say it's a similar thing. Know your client. There are some very unreasonable clients that nothing you do will ever be satisfactory, and that can be problematic. But the vast majority of owners out there are fair with us as architects, and it usually is something that can be worked out.
Time for one more, maybe, Hosty?
I think so. What would be an example of work performed by an owner's consultant that you as an architect would review and incorporate into your design?
Well,
yeah, go ahead. I was going to say we have owners hire interior designers direct all the time, but go ahead.
That was exactly what I was going to say. Quite often, and Pete, you do a lot of multifamily residential, as do we, and even though we provide interior design services, most of the time the owner either has an interior designer that they want to use, or they want a specific brand. And so we're often required to work with another interior designer, and usually they will do the design, but they don't provide the contract documents for their design, and we have to take that on.
Yeah, you got to figure out how to make it work.
Right.
And be legally responsible for it.
Exactly.
If you recommend the owner hire an ADA consultant, won't you then have another deadly clause of which you've already spoken? Problems with working with the owner's consultant seems like a catch-22.
I would always rather have another party responsible for ADA noncompliance. That, to me, is a risk that greatly outweighs the risk of working with that consultant. Sure, I'll send them my drawings. I'll ask them to mark things up. I'll have meetings with them. And all of that is going to be extremely well documented. So you can handle risks, but you have to handle them by understanding the exposure that comes from them and come up with appropriate ways to handle them.
Okay, well, that's all the time we have. There was quite a number of questions, so if you do have additional questions that we could not get to today, feel free to email docinfo@aia.org. Again, I want to remind all the participants that this webinar is recorded and will be emailed to you along with the PowerPoint by tomorrow. It's also eligible for one learning unit if you are an AIA member. Your credit will be reported within 2 weeks. Again, I want to thank our presenters for an excellent presentation, very helpful, and thank you to all of the attendees for taking the time to participate in today's webinar. Have a great afternoon.